Welcome to the CCI Grand River Podcast. I'm Michelle Dyer. Thank you to RLP LLP for our podcast studio. However, for the last episode and now for this one, we are outside the studio. Recently, we had the finest legal minds of the chapter get together and talked about relevant and interesting cases brought forth and ruled on by the Condominium Authority Tribunal in 2022. This was done in front of a live audience, and this is part 2 of those discussions. You should know the following is not legal advice. The legal panel is discussing the results from cases already heard by the CAT. If you have condominium concerns that you feel may require legal advice, please contact a lawyer directly. Second, you should know this couldn't have been possible without our sponsors. Thank you to Cohen Highley's lawyers, Criterium Jansen, Edwards Community Management, MF Property Management, Registon Building Restorations, Robson Carpenter LLP, Shibley Righton LLP, SV Law, Wilson Blanchard Management, and Woodhouse Restorations. Thank you for listening and enjoy the second part of the legal year in review.
How are we doing? Good. Good afternoon. Let's try that again. Good afternoon. Good afternoon. Fantastic. Well, everybody a cup of coffee. First and foremost, I want to thank Teresa for putting on what I think, where is Teresa? Right there. Teresa, this is the nicest wedding I've ever been to. There is no wedding party. There are no in-laws. There are no gifts. And there's no dancing. This is perfect. This is the perfect wedding I've ever been to. It's a pleasure to be here, folks. I'm going to be speaking on a few cases. I have no idea what I'm speaking about today. The panelists gave me all the cases they didn't want to talk about and gave them to me. You think I'm kidding? Probably not. Okay, how many people in the room are property managers? And show of hands. Fantastic. This first case is for you. Where's my little clicker? Okay, so for property managers, quick hit. McLaughlin versus Brent Standard 75. This is a property manager who will remain nameless. They're in Brantford. Begins with an M. I won't say anything more than that. I don't think they're here today. Okay, someone's laughing. So this property management firm did a lot of business with the condominium corporation that was perhaps beyond what most people would expect in property management services. Garbage removal, maintenance repair, a whole bunch of series of services that, maybe were pushing the envelope a little bit, but all legal. A unit owner said, I want to see all those contracts. I want to see all those records. I want to see the work orders. I want to see all of that. The manager said, hold the phone. You don't get to see that because those are our corporate records that show our competitive advantage in the industry, and denied the record request. The CAT said, not so fast. Those are producible. The quote is, protecting the business interests of the condominium management provider is not a valid reason to refuse or provide a record. Are we really surprised by that case? Who's surprised by that case? Anyone? Put your hand up if you dare. Really? I'm kidding. What it tells us, though, is this. If you are a management provider, there's a lot of you in the room, if you provide something to the condo and it becomes a record of the corporation, it's likely going to be producible. So if you have anything of emails between managers or policies in the management agreement or policies internally, all that sort of stuff that you do that makes you great at what you do, and that falls in the hands of the corporation, that is likely going to be producible. So always keep in the back of your mind what you give a condo might actually produce the CAT procedure. Okay, how many people are board members in the room? Show of hands. Oh, I'm so sorry. So sorry. The pay is great. Benefits are even better. Pension's fantastic. Right? Okay. This case is really for board members. Jasper Developments versus York CC number 82. York CC 82 says, on a record request, we can't give you the records, Mr. Jasper Development Corporation. And here's why. Because the previous manager won't give us the records. How many people have seen that before? Oh, all of us? Didn't get the records on turnover. York says, we can't produce any records to you. We're blaming the previous manager. CAT said on request, not so fast. A condominium corporation cannot blame a property manager or abrogate its duties to another manager. Where does the buck stop then? Board members, take a guess. At the condominium corporation through the stewardship of the board. It is up to the board, ultimately, that they have adequate records. Now, you might have a complaint against the manager in another proceeding, granted. There might be a CMRAO complaint, granted. But the relationship with the owner is you have to have records for them, and you can't blame a third party for it. So board members, probably likely, it's a good idea. Annually check what your records are. Maybe keep a USB stick in a safe place. I know managers are now going to be not very happy with me to put more jobs on their plate. I will be running out of here as soon as this is over. But it's up to the board to ensure they have records. And they cannot have as an excuse that they don't blame on the manager should the turnover not occur. Okay, how many lawyers in the room other than the panel here? Anyone else? Michelle, Jonathan? Michelle, put your hand up. You're a lawyer. Really? Michael, I'm going to pick on you. We're going to... Yes, Mr. Clifton. We're going to talk about Mr. Clifton in a few minutes, but not quite yet. This is a case that our firm lost. This is the case of Core versus Niagara South CC number 12, in which Mr. Core, I don't know why he would want, but he wanted to read all of the accounts that Smith Villariat produced to Niagara CC number 12. He wanted to read everything. He wanted to read all of the legal accounts produced to this condominium corporation. Mr. Coburn's in the room, I believe. Mr. Coburn argued the case, and he said, hold on. There's about 300 years of case law that says that a legal account is privileged and confidential. You get to talk to a lawyer, and that lawyer, on the pain of death, cannot repeat what you told him or her. Right? And the account follows in step. Well, this went to the CAT, and I know you're probably going to be a little surprised, but the CAT disagreed with that opinion. And they said that the record, the legal account, is producible. It is a record of the corporation, and it is producible to the unit owner. But wait for it. You'll take out the narrative description of the services provided. You'll redact the dates of services, the hours billed, the hourly rates, fees billed for each service, and even the identity of the lawyer is all redacted. So isn't this a great case? Jamie lost, but everything is redacted. Everything. The only thing left on a legal bill then is the bottom right column, the amount. That's it. Oh, Michael, we're going to pick on you in a few minutes. Fantastic. Okay. Next case. This is for the managers in the room for sure. How many of you have received multiple record requests from one unit owner in 1 year? Show of hands. Oh, come on. Really? You're lying. There's more of you. How many people have heard of a unit owner making multiple record requests in a year and have had to endure it? Yes. And how many people have maybe argued at the CAT those are not producible because there's so many record requests? Anyone try? There's a couple cases on that. The recent case on this is Emerald PG Holdings versus Toronto Standard Corporation number 2519. This is called a fishing case, fishing expedition case. This unit owner said, I would like minutes that go back 10 years. I would like every contract. I would like every financial statement. I would like every email, every letter, you name it, I want it. And I'll pay the fee. Unit owner said, the corporation said, not so fast. This is too much, and we can't do all this for you. So, the CAT agreed, and said that casting a wide net is a characteristic of a fishing expedition. Now, a fishing expedition in legal parlance is not a compliment. It means you're looking for something, but you have no idea what you're looking for. You have a drag net going. You have a net in the water, and you're looking for something you don't think might be there or might not be. You don't know. A fishing expedition is generally considered to be pejorative. It's not positive. CAT said, I find this request is overly broad, lacks specificity, is focused on finding imagined wrongdoing, and meets the general definition of a fishing expedition. Record was denied. This is excellent. This is a win in favor of condos. That if a unit owner pushes the envelope too far or demands too much, we might be able to deny the record request based on this being a fishing expedition. So it's a great case. I won't say who was on it, but we'll leave the names. Anyway, it's all good. Okay. Okay, how many boards in the room? How many board members? Show of hands. Great. This case is for you. So, we all know about the lien power, right? Okay, we can lien a unit owner if they fall into arrears. If you don't pay your monthly common element fees, you are going to have a notice of lien and a lien registered against your unit. That is the act. That's the legislation. Right? Do you think we can abuse that? Do you think we can leverage those powers? Michelle's nodding her head. I won't even start. Okay. In this case, Carlton Corporation number 56 versus Shireen, that's exactly what they did. There was a plumbing incident which required a $14 part and $100 repair by a plumber in a unit. Corporation pursued against the unit owner, pursued with a lien. Unit owner finally paid under protest and said, I'm going to pay you, but I'm going to pursue this elsewhere, and brings a small claims court action. Brings a proceeding in court. The condo says, okay, you paid us in full, but we're not going to take the lien off until you stop your action. Now, do we think that's written anywhere in the legislation? We're going to lien you if you litigate. Could you imagine if that was written in the legislation? That'd be fantastic. We could lien everybody. But it's not. You are liened if you are in arrears of monthly common element fees. That's it. You don't get liened if you're litigating a condo. You don't get liened if you offend the president. Everyone would be liened. You don't get liened if you offend the property manager. You get liened if you're in monthly common element fee arrears. That's it. So they took it all the way. The condominium corporation brought a power of sale proceeding in Superior Court. And the Superior Court said this: don't ever weaponize a lien. Ever. That's what the takeaway was. You're in monthly common element fee arrears? Sure. Do what you have to do as a condo. Other than that, you're using leverage and weaponization, and you're abusing the power available to you as a corporation. Now, this section of the Act is near and dear to me. I love the lien power. Could you imagine if we didn't have it? We'd be going to court for everything in terms of arrears. But we have this power, so it's very important we don't abuse it. This corporation did, and if we have too many cases that read like this, conceivably we could lose this section of the Act. Now, I don't think that's likely, but we don't want many cases to read this way. So we should all remember what the power of a lien is. Monthly common element fee arrears. That's it. Okay. I said I was going to pick on Mr. Clifton. We do have a special guest who we have not honored in the room as of yet. We have the vice chair of the CAT in the back, Mr. Michael Clifton. Michael? We're going to end this session all at once saying thank you, Michael, for all these cases that we're reading today. Thank you, Michael. It's a pleasure to have him here. These are some statistics that are coming out of the CAT right now, and our firm's compiled, and I'll wrap up and then we'll get into the Q&A. Some people think there's a bias maybe at the CAT, or a predilection or presumption or a direction that CAT decisions are going. They may be right, they may be wrong. There certainly seems to be a certain glide paths that the CAT is taking. The first is if it's a records case. If it's a records case, statistically, from 2018 to current date, the win-loss is 75% in favor of the unit owner. Okay? So what does that mean? If you're a unit owner asking for a record, you're going to get it 3 out of 4 times. If you're a condo trying to fight off a record request, ball shots. You have a 25% chance of success. Now, I don't think that's particularly surprising, because we know the presumption in the Act and the case law says open book. So it appears to be that the CAT is following the open book principle. However, the penalty is high. If you're a unit owner and you're denied a record, you have a 75% chance of success and a 68% chance of the cost order in your favor. Now, the ordinal of the cost might not be particularly high right now, generally about $200, but still, be aware, if you're a board or a property manager or a member, what have you, lawyer, all of us, if you have a record request, it's going to be very difficult to deny it. However, things change. All the other cases, being enforcement cases, have a very different result. Now, these are relatively new. The sample size is not as large. But if you're a condominium corporation seeking enforcement, you again have almost the same statistical likelihood of winning, 74%. So if you're going after a case on pets, or parking, or storage, or nuisance, or all other stuff that's light, now we have a light case. Whoever knew we'd have a light case? Now we have a light case. Condominium corporations generally are going to have a win-loss ratio of about 74.55%. But the statistic also perhaps belies the bias. If you are in the record request column, you're going to get 68% likelihood of cost if you're a unit owner. But if you're a condo, your likelihood of cost is only 35%. Why is that? I don't know. I guess we're just going to have to figure that out as times go on. But I have some beliefs. I think the belief is that the tone that the CAT expects of managers, lawyers, and board members, which is exactly what the cases that Annie was talking about, I think they're looking for proper investigation. I think they're looking for tone. I think they're looking for professionalism. I think they're looking for escalation that is proportionate and relative to the actual events in question. And if you're going to the CAT knee-jerk on the first letter and doing a big chargeback pursuit, and perhaps the letters are a little more aggressive than we would expect, I think that's having a downward pressure on the cost case for funding corporations. Now, that's just my anecdotal. That's not statistically bound in anything. So, core message to all of us, at the CAT, records are probably going to be produced, and generally the presumption is in favor of compliance, which is also in keeping with legislation, but your costs might be quite mitigated or moderated. So always be mindful, but those are the statistics from 2018. Jamie, over to you.
All right, we'll open the floor for questions, comments. I'm just going to repeat the question for the podcast recording. So the question was, there's a board member, former board member who is current board member who would like to act as a handyman, handy person for the condominium. What are the concerns with that?
This is not legal advice. So I'm not going to comment on any on your specific situation because there's a whole host of reasons why not. But generally, I prefer that people who are doing contractor type work are separate from the board and ideally even the condo, and are brought in under a proper contract, etc., because there can be significant liability issues.
That's what we thought. I just wanted to confirm.
Again, this is not legal advice with respect to your corporation specifically. Just a lawyer.
If someone asks for records, for example, board meetings, okay, and the board says, no, we've had meetings, but we don't keep records.
So the question is, if someone requests records like board meeting minutes, but they don't have board meetings, how do you proceed? Or sorry, they don't keep minutes at their board meetings.
So there have been at least one or more CAT cases on this already, and the way the CAT treats it is this. It would be really cute and easy if you said, no minutes, no produso, but like easy as that. The CAT doesn't look at it so fondly or charitably. The CAT in some of those cases has found you ought to have had that record. That is a record that ought to exist, especially something as fundamental as minutes, and has awarded, can't in the case of long past minutes, can't really make you go make them, but can impose a penalty and costs potentially. Yeah.
What is the turnaround time at the CAT now? Michael Clifton?
I'll jump in just because I have the mic. It gets rolling fairly quickly. The duration of it will depend on the complexity of the case itself, but once a case is commenced, it gets rolling fairly soon, and you'll get your first notice to start stage one, and then it can take usually anywhere from 2 to 6 months to resolve.
So the question is, what's an appropriate number of notices before you proceed to the CAT?
No, you don't have to. No, it's funny because I was thinking that when Annie was talking about it, that I feel like there's a happy medium somewhere between those two cases. I would have gone for 4 and 4, especially for something that consistent. I would say, 1 or 2 from the corporation, and then, well, in a case that's that extreme, I'd say probably just only 1 from the lawyer. In some cases where it's not as significant, maybe 2 from the lawyer. But yeah, I would definitely do that.
So the question is there a time limit from when you start a cat case or from when you start?
No, if you're warning somebody about noise, say you warn them on January 1, then you warn them again on January 15th, then you don't bother until April 15th. You 90 days. Is that detrimental?
Every case, first of all, I think you should send 1 million legal letters on every file. Every file. I'm kidding. We don't know. Every case is fact specific. But the courts will take cognizance of the longer delay between letters. There's no question about it. So if you have one complaint letter in January and the next one is September, they're going to take cognizance of that. They're going to say, well, what's the delay for? You better explain it. So I would keep tempo, 3 or 4 letters, maybe within each pattern of 30 days, maybe. But if you have a hoarding case, folks, if we find a unit that's subject to hoarding with whatever you want to insert the blank on the hoarding, and we've seen it all, cases show, I don't think we're going 30 days letter. We're probably going 15 days letter, and then off to court 15 days thereafter. So it's always proportional to the situation.
Just an additional comment on it. There was a cat case within the last year or so that played on that angle, and I believe it was parking related. Someone was doing some parking mischief. Condo wrote either a letter, I think it might have been a legal letter, and the mischief went away. And then 6 months later it came back, and they went right to cat or court instead of writing another letter. And the commentary of, I believe, the cat was, well, the first time you wrote a letter, it got it fixed. Might have been they slipped up, might have been that they had a bad day. Why would you blast ahead to court or cat 6 months later? What about another letter? And they were a little critical of that.
I think typically too, from a property management perspective, we would put a deadline on the letter. So if you haven't complied by this date, then we move forward to the cat. So leaving it open-ended can be a little bit tricky. Go ahead.
Is there any case law regarding, let's say the tenant in the unit is the cause of the noise, the nuisance, the disturbance? Are there any cases before CAT which say what is the owner's responsibility to respond or deal with that tenant, given that that tenant has certain rights under the Landlord and Tenant Act? It almost seems as if there's you've got to figure out which act takes precedence.
So the question is, how are tenants handled in terms of the CAT in relation to the owner?
Actually, what responsibility does the owner have if it is the tenant who is causing the noise or the nuisance?
Okay. I asked for this because I also practice landlord and tenant matters, and this comes up all the time in the condo world. I see this so often. So the owner is responsible for the tenant's behavior in the unit. Essentially, the tenant is the owner for purposes of how they conduct themselves in the unit and in the condo. So in most cases, you talk to the owner, you get them to work on dealing with the tenant, whether that's through letters or taking things to the board. The only time that I would say that the condo gets involved legally is if the landlord unit owner is not taking those steps, taking the reasonable steps to deal with it, at which point you can go to court. The CAT has made it clear that it doesn't have jurisdiction over dealing with tenancy in terms of like eviction or termination of tenancy. Absolutely, as is appropriate. It does not have that jurisdiction. There have been a few cases where tenants have kind of been brought in to CAT matters because they were involved, and I don't actually, does anyone know about the specifics of those?
Tenants?
Yeah. Like the CAT cases that deal with them.
I think there was 3. There's been a couple, I can't remember off the top of my head, but there's been about 3 cases, I think, this year that dealt with tenants, and tenants are bound by the legislation. They're deemed to be a unit occupant, and the fact that their tenant doesn't give them... Could you imagine the precedent if tenants weren't captured? They could do whatever they want. Woohoo! We're in a condo, we're in a tenant, can't touch me. Yeah. So yes, the CAT does take jurisdiction over the behavior of tenants, and we'll look at the interplay between the tenant and the unit owner, pursuant to section 119, I think so 2. Says the owner is ultimately responsible, but we'll still give an order to prohibit the behavior that they're seeking the tenant to stop. Of course they will with that order, I know, but that was a joke.
Yeah, good. I get it.
Sorry, I just wanted one comment. Actually, we recently talked about doing like a webinar or something or seminar on landlords and tenants and condos. But people, hands up if you'd be interested in that. Okay, that's what I figured. All right, good to know.
Very quick follow-up on that. Unfortunately, during pandemic, owners have been in a really tough spot in those cases because if the board says, or the manager says, go to the LTB, get it sorted, LTBs are like 12 to 18 months behind, and then the behavior escalates, and now the condo has no choice but to start.
So the question is, does an emotional support animal need to accompany the owner at all times? Can it be left alone in the unit?
I think it's going to be very dependent on the specifics of the disability and the reason for the need for the animal. So, for example, if a person lives alone and they get anxiety when they're alone, but at work they're fine because they're surrounded by people, then it makes sense that they would only need their dog in the unit. So you're going to need to get the specifics of what accommodation is required and how the dog is accommodating that, again, without overstepping and asking for a specific diagnosis, because every disability is going to be different and every disability is going to require different accommodation.
So who makes the decision and how specific can we get into the details? Because you have to respect the privacy of the person, but you also want all kind of documentation to support having the dog in that property.
Yeah, it is definitely a balance. So the question is, how much can you get into the details versus how much, you have to respect privacy. Again, so ask your lawyer. But again, basically, a doctor's note outlining what needs to be accommodated. So I'm in a wheelchair, so I need a door that can fit my wheelchair, etc. Right? That kind of thing. You can't ask why they're in a wheelchair, obviously. So it again is going to be fact specific on exactly what the information is, but the basic guideline is what accommodation is required and how is the accommodation they're asking for addressing that need.
Because the certificate that they give you is very wishy-washy. Like there's nothing there to really give you any details or real solid knowledge of, yes, it is.
I echo Stephanie's comment. Speak to your lawyer, but the person asking being requested to accommodate is entitled to ask some questions and get some information. One good practice is, if there's just a loose discussion first and that letter hasn't come in the door or a medical note, to ask your lawyer to provide you with some questions that the owner or resident specifically needs to bring you the answers to, and they will be tactful and they will be balanced. But that way you're not just going to get the note. We've all seen the note that says, Mrs. So-and-so requires this dog, signed walk-in clinic.
So the question is there any kind of survey or information on the average annual legal fees for condos? Just as a property manager, the legal fees for each condo that we manage are so varied. They can range from zero to the tens of thousands. So it would be very difficult. I think you'd have an average number that really doesn't mean a lot of anything, I don't think.
Other than as a minimum.
Yeah.
Even if you didn't have any legal action, you probably should have a minimum amount.
Sure. I think what she's asking with the minimum amount in a budget, typically we would always throw bare minimum, $250 to $500. That might get you one letter or two, maybe if you're lucky. That would be a fair Go ahead. So just to repeat the question, this might be a good one for Annie. It was in regards to the condo the owner that was awarded costs because the condo only sent one legal letter before they commenced the CAT proceedings. So Annie might know whether they had a property management company or not. And then a follow-up question, if they did have a property management company, what recourse does the board have against the management company for taking that action?
Yes, I believe you're speaking about the second case where the owner was reimbursed for his costs.
Yes.
Yeah, the case didn't mention a property manager. It might have been self-managed. I'm not sure.
Yeah.
It's on. Okay, it's not close enough. Okay, so that second case didn't get into, I don't believe there was a property manager in that case, or at least it wasn't mentioned in the decision. And it is ultimately the board's decision to decide what action to take. So the decision looked at the board's duty to take reasonable steps to ensure compliance, and that's where the focus was.
Also, property managers are wonderful and they have a lot of really great expertise, but they're not lawyers and they don't have legal expertise, so don't rely on them for legal advice. I'm not saying that to put down the managers. I'm saying that you can't hold the managers responsible for legal decisions. If you need advice, go to a lawyer.
Fully agree with Stephanie as a property manager.
Sponsored by the Law Society.
And not that I want to, I don't know your specific situation, but the Condominium Management Regulatory Authority of Ontario, if you actually suspect that they have been truly negligent, that's always somewhere you could turn.
It was strictly hypothetical with respect to that case.
Gotcha.
Nothing going on here.
Okay. Go ahead.
With so many meetings being held virtually and the recent CAT decision to make meeting recordings a record of corporation, I'd like to hear the comments from the panel on that as a condo manager who's responsible for keeping those records.
That's a great question. The CAT had a recent case where they ruled that recordings of AGMs are records, which contradicted, I think, a previous case. Because now we're holding meetings virtually, often they're being recorded for mostly minute-taking purposes. So I'll let the panel handle it.
I think probably each one of us want to speak on this because this is huge. It's a great question. So until recently, those recordings we had, like at Forum, were deemed not to be a record of corporation and not producible. Not a record, not producible. Recent case says it's a record now of the corporation, but fell just short of production. They got really close and said, we just don't think you have a proper purpose for it. So they're halfway in the argument. These are going to get produced. It's just, in my humble opinion, only my opinion, it's a matter of time that these meeting recordings are going to be record and producible. Therefore, it would be my humble opinion that any recording that you go on, anything that you participate in, you deem to be a record when you participate. Everything's on the clock, everything's on the record. Treat it like it's a record. You might be able to deny it if it's a record request, but I think where the cases are going, it's going to be producible.
In the practical tip, in the dress rehearsal, which a lot of these meetings, especially AGMs, have, the board needs to make a decision and advise the host company. Some boards have been choosing, we don't want to record this. Let our minute taker record it on their own device, like they always did when they were in the room. And we don't want a corporation copy of that. There are arguments and preferences each way, but I totally agree with Rob. If it's touchable by the board or management, it's going to be a record and it's going to be producible.
Yeah, we all have opinions on this one. Sorry, Michael, I think this is a terrible decision. Because I think got to the right result in the end, but for the wrong reasons. I have serious privacy concerns about this, right? Because if people, I guess you're saying to unit owners that it is being recorded, so they realize that, but they're not expecting it to be a permanent record. They're not expecting their image and their voice to be out there permanently for anyone to request. So I don't think they should be producible. I agree with Rob that they probably will end up being producible. Really the only way to get around it, if you really want that recording, is I think to say, so like your lawyer's hosting the AGM, the lawyer record it for their purposes to verify their notes. If the minute taker needs to verify anything with them, the lawyer can say, I will take a look and verify that for you. But I agree, the minute that it gets in the corporation's hands or possessions or ability to review it all, I think it's going to be a record, unfortunately.
And my non-lawyer perspective is that it's going to open the door for unit owners saying, hey, I had a dentist appointment, I couldn't make it for the meeting, can you just send me the recording, which is not really what the purpose is.
Can I follow up? Sorry.
Oh, yep.
For board meetings, for example, I assume it covers board meetings as well, though?
Does that case include board meetings? as well as EGMs?
Not directly.
No, it didn't deal with it. I'm gonna say err on the side of caution and don't record your board meetings. Yeah. 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 It just generally, 'cause you're talking about like confidential and private issues, and yeah, I wouldn't record them anyway.
Go ahead.
This is a noise question in relation to a unit owner and the builder. So the question is, if builders make a major change to their construction that ultimately ends up affecting the unit owner in her or his unit, is the builder required to disclose major changes during construction to the purchaser?
Great question. The question was, is the builder required to disclose major changes to construction to the purchasers?
I think there's many parts to that. It depends on what the change is. Changes to disclosure need to occur if it's a material change, which is defined under the Act. I'm not sure that any construction falls under material change. Let me know if anyone disagrees with that. So then it would also depend the stage of the corporation. Is the condominium registered and they're doing a separate phase, or?
No, it's a new build that's about just over a year old.
Units have been transferred, people are, they own their...
Well, yeah,
Oh, okay.
we're out of occupancy. This unit owner in particular was in occupancy and tried to discuss the matter and was pretty much forced into closing or losing their unit. So it was, they wanted to stay in occupation and were recommended from the lawyer they were speaking to at the time to close and then take steps from there.
Do you want to speak to some of that? Sounds like your thoughts. I would like to.
I have no idea. It sounds like a unit owner is suffering acoustical entry, like noise,
Yes.
and we think it's a builder.
Yes.
Okay, so you probably want to check. You want to probably have that included if you still have the time on your performance audit, and see if that's captured through Criterium,
Yeah.
and then pursue that route.
Okay.
That would probably be your most efficient route to probably address those issues, right? Hypothetically speaking.
Right.
Please use condo lawyers
And
for condo matters.
quick follow-up, Sherry. And if it does get to a point where there is a 2-year litigation period where they could pursue litigation, what do you think the success rate is of taking it all the way to the Supreme Court if necessary?
Okay, well, it definitely will go to the Supreme Court, because the Supreme Court only takes matters that are of public interest, and I don't think this is going to meet that standard. In terms of being able to predict success rate, absolutely fact is dependent, impossible to comment.
Thanks.
They should continue to speak to their lawyer, a condo lawyer, because there are multiple overlapping limitations. Keep in mind the common elements. It's 2 years plus 6 months before even the board can conciliate, the corporation can conciliate. The owner, maybe 2 years from civil litigation from when the problem started to bug them, and there can be weird interplay. They should certainly discuss that with their own lawyer to make sure they feel they're protected.
The question is, can you destroy recordings that you've already made of past meetings?
Doesn't say it in your minutes.
I'll be the sacrificial lamb. I'll be the sacrificial lamb, and it's based just on my read of the CAT. Keep in mind the Act and the regs require the corporation to keep records, including but not limited to those set out in the Act and their bylaws. Based on, we talked about the one at the minutes earlier, you didn't keep the minutes and therefore you can still be penalized. I think boards need to be very careful about destroying records that already exist, lest there be a presumption that something was in those records that they tried to destroy.
So we do have physical copies of every minutes, but we also have recordings of meetings. So we have both.
I hear you. I like it. The skeptical owner and skeptical CAT member or judge is going to say, well, there was something else in that full narrative wasn't there. That's the risk. Be very careful.
Okay, last question over here. So the question is, have there been any CAT cases related to reserve fund studies?
Sorry, everyone's saying the same thing. It's not one of the items currently within the CAT's jurisdiction.
It's not the jurisdiction of the CAT, but just a comment on one of your comments. Folks, there is no overfunded reserve fund study in Ontario. Okay? You can't be too aggressive. Not one of you has a properly fully funded reserve fund study. And ma'am, I have the mic, so I'm just going to turn it off now. Okay.
All right, we have no more time for any questions. That was great. Can we give another hand to the speakers, please? Thank you everyone so much for attending today. I know it's a really busy time of year, really close to the holidays. Thank you to the CCI Education Committee and to Teresa and her team for putting the whole day together. And happy holidays and see you in 2023.
We hope you enjoyed part 2 of our series with our legal panel, A Year in Review. Thank you once again to our sponsors, Cohen Highley Lawyers, Criterium Jansen, Edwards Community Management, MF Property Management, Registon Building Restoration, Robson Carpenter LLP, Shibley Righton LLP, SV Law, Wilson Blanchard Management, and Woodhouse Restorations. We couldn't have done this without you guys. We hope you'll tune in to the CCI Grand River podcast next time when we'll speak to the CCI Grand River committee chairs about what's in store for the next year for this chapter. Thanks for listening. I'm Michelle Dyer.